Chair Biederman, whenever you're ready to go live, let me know. All right, Michael, are we live?
We are live.
If you would all just please make sure to speak clearly into the microphone, we can hear you on Zoom that way.
So if we can take the order, take the roll, please.
Member Amer,
Present.
Member Black,
Present.
Member Brennan, Member Miller,
Present.
Member Puentes, Member Sullivan,
Here.
Chair Biederman.
Here.
You have a quorum, Mr. Chair.
Okay. And did I understand that you said that who was excused? I didn't.
Christine Brennan notified me that she would not be able to make it. However, I did not hear from Mr. Puentes.
Okay. Well, we have an agenda that I don't know if the audience has it. Involves two. We'll get into everything, but we'll go through all the steps. But we do have an agenda that involves two complaints that have been filed, and then a general topic for discussion. So, should we start with the approval of the agenda? Is there a motion to approve the agenda? Seconded, anybody?
Second.
Okay. Any objection to approving the agenda as it appears in the packet? Seeing no objection, it is approved. And then as far as minutes, and we didn't get these before today. So I believe we do have them now.
Chair Biederman, no, there are no minutes to approve for this meeting.
Okay. So pass on that. So we'll go straight to the discussion and possible action items. The discussion, we have two complaints, both brought by the same person, and against two different candidates for mayor, involving the filing of the names of the treasurer, basically on campaign material. And I see in the audience that Commissioner Green is here. I don't know if there's a representative or anybody else. Okay. So the obligation of the commission of this board today, let's see if I can find that section, is not to adjudicate this issue, but to see if there is a prima facie case basically made by the complaint. Just is there. Okay, so under 6-16.4, the board needs to determine if the face of the complaint sets forth legally sufficient facts, which, if true, show probable cause to believe that there was a violation. Also, if the complaint was filed within 1 year after the complainant first discovered or reasonably should have discovered the facts on which the complaint is based, if the complaint is frivolous or intended solely to harass or intimidate, and whether the board lacks jurisdiction to adjudicate the complaint. So that's our obligation today. We can't go beyond that. And let's see, I think since we have Commissioner Green here, I guess we'll just go with him first. That was that the first or the second?
Chair Biederman, that's the second complaint.
If there's no objection, let's go out of order since Commissioner Green is here. Okay. So just to set the stage here, I'm not arguing anything. The objection or the complaint alleges that a fundraising flyer is missing the treasurer information when it's distributed. That's all it says. And it cites a section which is actually not the campaign code section. I think this was a handout by the clerk's office, but section 6A, identification of campaign material. And this filing appears to have occurred within a month of, let alone a year of of when the material came out. So on the first one, we have not heard a response, at least the members of the board haven't received a response from Commissioner Green, right? But he's here.
Chair Peterman, that's correct. We did not receive a response.
Okay, but he's here. So again, the issue now is whether there is sufficient evidence, sufficient allegations, I should say, to go ahead on the assumption that if the facts were true, that would be probable cause to believe that there was a violation. Has everybody had a chance to look at this complaint? Okay. Any comments on that issue at this time, whether we should proceed or not? We don't have a, well, I guess we should have a motion for discussion first.
When we hear from Commissioner Green first.
Would you like to? Okay, we can do.
Certainly part of the process is a response from the respondent, and I
Oh, yes.
want to hear that before we talk too much about it.
Okay, let's do that then. Commissioner Green? And who's your representative?
Mr. Chair, thank you very much. Justin Green, candidate for mayors. I have Peter Dwyer, an attorney here to represent me because I'd be better at this than I am.
Okay. So you understand the allegations of the complaint. How would you like to respond?
I'll respond on behalf of Justin.
You speak into the microphone.
Oh, I'm sorry. I forget we're on Zoom. If you look at the complaint form, you'll see, start off with that at the top, they have not used the correct form. I don't know where this form came from. I went to the city's webpage today and I looked at the clerk's office's form, and it does not say if you look at the first lines on the left, it says City of Santa Fe SFCC section 16-16. That is an incorrect citation, I hope, because otherwise the citation is under the city's criminal code. Chapter 16 is the criminal code, provides for criminal violations of the city's ordinances. And obviously it would be fundamentally transformative if this was a quasi-criminal proceeding. Those are authorized in certain cases, but the process would have to be very different if we were actually dealing with a criminal charge here. So I'm hopeful that the board will agree that that is a fundamental error and very problematic to be citing to the criminal code. Section 16-16, by the way, does exist, but it is reserved section. 15 and 17 are specific criminal provisions. 16 is reserved. So I imagine that it's a typographical error, but I feel that it's a critical one. I do not think that my client should be wondering whether they're being subjected to criminal penalties based on the complaint. Next thing I would be concerned about is that in terms of witnesses, the provision in the complaint is person in charge of materials is all it says. It does not identify any person. It just gives a vague statement. I would have to guess what that meant. And that would not be helpful in preparing our defense if we had to guess who were the witnesses that the complainant intends to call. We would have to know more. I understand that this is the preliminary step of the procedure and maybe that would get fleshed out later, but it's just another example where complaint on the face of it is really not meeting the standards that are required to rise to the level of a demonstration that the complaint has legally sufficient facts for this board. And then the last concern I have, I understand this is on the city's form, but I don't understand why, is that at the end, it is signed under notary with, to the best of my knowledge, the above statements are true and correct. which to me is not legal standard. The legal standard, if it goes to a hearing, is going to be that there has to be clear and convincing evidence. And the legal standard for the complaint itself is set forth in the board's rules of organization and practice, section D, which says sworn complaints may be filed by any person pursuant to 6-16.3 on a form provided by the clerk. And I would contend that this is not a sworn complaint. Sworn complaint would have to state that the person was making the complaint under the pains and penalties of perjury, thereby subjecting themselves to some kind of some putting themselves in the position of saying, no, I take this seriously. I'm willing to swear under oath. That's what, if you look in Black's dictionary for the word sworn, it's going to tell you it has to be under oath. So I do not believe that this complaint meets the prima facie requirements for a legitimate complaint under the city code because it is not sworn. So with those contentions, we would respectfully request that the board dismiss this matter as not meeting the requirements under the city code and also the rules of organization and practice adopted by this board. Thank you.
We'll take questions from the board. Mr. Dwyer, please stay at the podium. Questions of council?
Sure.
If if it fulfilled the sworn complaint standard, what would need to be done to make it sworn?
Normally I'm a retired attorney now, so I can't say that my understanding of the Notary Act and the changes that occurred in the past few years are comprehensive. But normally under the revised Notary Act, that's only going to be a attestation of sorts by the notary that the signature is of the correct person. It's not going to make the statement itself, the assertions, the factual assertions or the attachments, true and correct copies. It's not going to make them testimony. It's not subjecting them to any level of scrutiny at all. They're just mere assertions without any kind of basis or support. And, the authenticity of the document is not shown by the notary. But most importantly, the person who's making the complaint is not subject to that basic hurdle that all U.S. justice requires, which is if you want to complain about somebody, you've got to be willing to stand behind your complaint and say, I swear under the pains and penalties of perjury that the things I'm saying are true. So I think it's deficient as a whole.
So are you saying that it would have to be, there'd have to be a seal of a notary there?
No, the notary is, to me, is insignificant. There would have to be the person would have to swear an oath, whether it be in writing or in front of a person. And I don't believe that the notary is the appropriate person to swear an oath in front of. Obviously, when you take testimony in your actual hearings, I know this isn't a full hearing today, but when you swear the witnesses and your rules provide exactly that language. Your rules say that when witnesses come to present evidence before you, they give those specific language that the chair is supposed to read, swearing them in and making sure that their testimony is under oath. But that same standard is required of the complaint. And if the complaint doesn't go as far as, averring that these are truthful statements and just relies upon a very vague statement that, to the best of my knowledge, that's not a legal standard I'm familiar with in any context.
Is it appropriate to ask the clerk a question? When complainants bring complaints in, do they ask you to be a notary or somehow certify their signature?
Yes, usually when we receive a complaint, they ask that we notarize it for them. And on this one, I will say that I did fail to stamp my seal on it, but I did acknowledge this signature.
Thank you.
If I can just add that it's only helpful to prove that the person who says that they're making the complaint is that person. That's all that the notary would ever prove, that it is in fact the complainant in front of the clerk's office. But as to the complainant's statements, the notary is not going to say anything about that. They don't know the truth or facts of that. They're going to rely upon the person making the complaint or the truthfulness of the assertion. So I don't think it's helpful that it's notarized. I don't think it matters.
Okay, other questions?
I'd just like to follow up with the clerk. I mean, is this the standard form that you all use for these complaints? And then why, if it is, why is it marked with the SFCC section 16?
Chair Biederman, Member Black, this is the form that, as far as I've been in the clerk's office, that we've used. I'm sure that it went through an approval process through this committee or this board. However, I've never seen or snapped to the 16-16, or has that ever been brought up? But I do believe that to be an error. It should be 6-16.
Is that it?
Thank you.
Okay. Anybody else, questions for either council or clerk?
I don't have questions for Mr. Dwyer, but I have some points to raise before. Are you ready for that?
Well, let me just raise just one question with the clerk myself. So this is the form that people are given when they ask to make a complaint. They are given this complaint form by the staff, right?
This form is available on our website.
Okay.
And if requested, this would be the same form that our office would give out.
Okay, and is there any, I noticed that the complaint refers to section Roman numeral 6A. And it in fact attached Roman numeral 6A. Attached language, which is identical to what's in our code, but not under that number. I noticed that it was under a different number. So it was, let's see, I have to find it. And I'm just wondering, was there a document that they were given that had that numbering?
No, Chair Biederman, this form was filled out already and the attachments were provided to me by the complainant.
Right, but do you have any notion, you can't read their minds, but do you have any notion where the 6 came from? Because it is attached with that number on it.
I think in just looking at the document, they may have been referring to the top part of the page that says 6 and then the Roman numerals at the bottom. That's the conclusion that I'm coming to. But yeah, I cannot read their mind. I didn't know what her exact intentions are.
Okay, so I mean, I think what the complainant is referring to is section 9-2.5, just for the reference of the committee. Whether we choose to accept that erroneous reference, that is the section that also is printed there. It's just with a different number. Okay. Okay, then we'll start taking comments. You can sit down, Mr. Dwyer, I think. Go ahead, Mr. Miller.
Thank you, Mr. Chair, and I thank you, Mr. Dwyer and Mr. Green, for being here. I would note for the record that the complainant is not here. As a matter of principle, if somebody's making a complaint alleging an ethics violation against somebody subject to the code, it would be helpful if they would show up to the proceeding in which we're trying to decide about the complaint. Your points, Mr. Dwyer, about the complaint form, I think are interesting and important, and our form should be correct. And I think we can do that quite easily. And I think it is correct that the rules require a sworn statement from a complainant. And that in itself is not hard to do. We can include language that says, I make this declaration under penalty of perjury, and the person signs it. That's a sworn statement. Whereas here, this is a signed form witnessed by a notary, which is just, as you said, a formal recognition that the person who signed this is the person who they are presenting themselves to be. So I think those are all interesting points and I don't know, what weight the board should give to them in consideration of the complaint, because they're rather technical. I would like to discuss more of the substance of the complaint and the actual allegations that are made, because I have concerns about whether the information on the form actually suffices to make an allegation of a violation of code in two significant ways. One, I don't see any indication that the flyer came from the campaign, and that's not, it's just nowhere in the complaint form other than citing to the section of the code that requires information from a campaign to state the name of the trust. But the allegations itself doesn't say anything about that. And from the flyer, there's no indication on the flyer that it comes from the campaign. It very well may come from parties who are hosting a fundraiser. In that case, it would be no such flyer. Wouldn't be campaign materials. I also don't see anything in the allegations that would suggest that these that this flyer meets the definition of campaign materials in terms of the number of people it was disseminated to. And I don't think this board or this committee needs to infer facts from the complaint in order to make it legally sufficient. I don't think that those facts are rather as a substance.
Other comments from the board?
Yes, it's interesting because the one section says campaign materials disseminated or communicated by a candidate. But then when you look at the definition of campaign materials, it doesn't, you reference the disseminated by, or communicated by a candidate. It just says any published communication. So in some ways, it seems like there's a contradiction between those two sections, but I would say since it's modified by disseminated or communicated by a candidate, that's an important piece here. And there's no way for us to know that here. So that's my only comment.
Either the other members have a comment?
Okay, I would agree with what Mr. Miller said. I have nothing to add.
Quick question on the bottom of the flyer that we were provided. It looks like something was cut off. I couldn't quite tell. And that could be also relevant information for this. So I was trying to check and see if we knew what was at the very bottom of that flyer.
Chair Biederman, Member Black, when we received the document, we did notice that that portion was also cut off. That is how we received it.
Okay, if there's no other comments, I do have my own. I'm on the one hand, well, I'm a little more flexible about accepting complaints in particular from people who are citizens, just members of the public. They shouldn't have to hire a lawyer to get everything exactly right. And I'm reminded of the magistrate court cases where people file in magistrate court, and very basic outline of the facts is enough to get them into court. So I'm not a real stickler in terms of getting all the facts in there. However, I think in this case, I am concerned as well. In addition, in the other case we're going to be hearing in a few minutes about Ms. Nix, where the same complaint, the identical complaint was filed. I'm concerned, except for the attachments. She raised the issue that there was no allegation that it had been distributed to 100 people. And that's in the campaign materials definition, that it's a definitional thing that unless 100 persons have received the material, it is not disseminated material such that it requires this notification of the name of the treasurer. So that is an additional factor, I think, that concerns me about the adequacy of this complaint. And, again, I don't want to hold people to the standards of lawyers. This is a body that is designed to hear the public's complaints about the government, about the people attempting to become elected officials. I do want to give them some slack, but I think this was such a broad complaint with so little information on it that I am concerned as well. That I really am concerned that it doesn't really give notice of what the problem is, and it doesn't really provide in itself enough information to sustain a judgment. So, is there a motion?
Well, I was going to say one more thing.
Please.
I agree with Chairman that in this case, the allegation of disseminated to more than 100 persons is important, because that's like a threshold. It appears that the code deliberately didn't want just some material that was maybe distributed between you and 3 or 4 friends to be subject to this complaint. So with that allegation, I think that it does make the complaint deficient. That being said, I think we should dismiss it without prejudice to allow the complainant to refile it correctly if they have additional information.
Is that a motion?
Yeah.
We have a
Yes.
motion. Is there a second? Okay, second by Commissioner Black. What are we, commissioners, board members, whatever? Mr. Black. So the motion is to clarify that it is a motion to dismiss on the basis of the requirement of rule of, I'm sorry, I got to turn the page here. There you go. Well, right, but it's actually the point that I wanted to make was the procedural point that it does not state a claim even if the facts are accepted as true. And that's because of the definitional issue, among other things. So, but it's a dismissal without prejudice. So we have a motion and a second. With clerk call the roll.
Member Black. Member Miller,
Yes.
Member Sullivan,
Yes.
Member Amer,
Yes.
Chair Peterman.
Yes. Okay, so the complaint is dismissed, but it could be refiled. Okay, and now turning to an identical complaint that's in our materials, except for the name of the candidate, which is now Tara Nix, and Ms. Nix is not here, but nor is the complainant, as you pointed out. And the attachments are different, but there is a difference in that she has filed a written response that we should have all received, right? Everybody got that written response, okay. So since there's nobody to ask questions of that I can see, I assume nobody's making a statement on this. So I'll just take comments or a motion from the board.
Commissioner Bienerman, if I may, in looking at all the documents today and being the youngest, not the youngest guy, but the newest guy on this thing, I ran the complainant's name, Victoria Murphy, and ran her up on US courts. And I may have a problem sitting on this as there is a lawsuit that a Victoria Murphy filed against Los Alamos County in 2018, dismissed in 2020. And it takes a while to refresh my recollection since I haven't been practicing the last couple of years. But I happen to represent Los Alamos County as the defendant, and she was the plaintiff on a whistleblower case. But we don't have a chance to ask her if it's the same Victoria Murphy, but there are not many Victoria Murphys around Santa Fe. I mean, Murphy is the most common Irish name. Sullivan is like number 4, but there are not many Sullivans around either. So anyway, I think I need to excuse myself because it may be the same Victoria Murphy I was in litigation with.
Should we, certainly, but should we also reconsider the last vote, not in light of the fact that you recalled this now? And allow you to excuse yourself because it's the same plaintiff, same complainant.
Same, yes, but I don't know if it's this Victoria Murphy.
No, and I understand, but it's the same person in both complaints. So whatever applies to one applies to the other.
Right, okay. Well, I agree. I mean, I think they're really good arguments you have now of collateral estoppel.
Well, yeah, but we don't want to get too lawyerly about this.
Neither do I.
So I would entertain a motion to reconsider the last vote and then vote again on that issue after you have excused yourself, if that's what you'd like to do. So
Sure.
we go through that procedure. Everybody?
I make a motion to revote with the recusal of Mr. Sullivan.
That's be okay. Is there a second?
I'll second that.
Okay, let's call the roll. Let's call the roll, clerk, and I guess Mr. Sullivan will abstain on this vote.
Member Amer,
Yes, on the previous motion.
Member Black,
Yes.
Member Miller,
Yes.
Chair Biederman.
Yes.
Motion passes.
Okay, so we've just voted to reconsider. And now, having remembered, and I can understand you had a lot of clients, so I can see where things could happen like that. Now that Mr. Sullivan has stated his reasons for recusing, you'll abstain from this vote if we do the motion again to dismiss the complaint.
Right.
Okay. So, Ms. Amer, would you like to read again?
Well, I have questions about this response. Again, it's not attested to
I'm sorry,
under,
we're talking still about the first.
oh, we are still talking about the
Yeah.
first one. Okay.
So if you want to make a motion to dismiss the complaint on Mr. Green's complaint.
Okay. A motion to dismiss Victoria Murphy's complaint against Mr. Justin Green based upon lack of on its face probable cause and failure to allege a violation of the dissemination by the campaign to more than 100 people.
And that's a motion to dismiss without prejudice.
Without prejudice, dismiss without prejudice.
Okay, and a second,
Second.
all in favor? I'm sorry, please read the roll again.
Member Amer,
Yes,
Member Black,
Yes.
Member Miller,
Yes.
Chair Biederman.
Yes, and note that Mr. Sullivan has recused because of the conflict. Okay, potential conflict. Okay, now let's go on to the complaint by Victoria Murphy against Taryn Nix. Same issue, not including the treasurer information on a fundraising flyer allegedly. Go ahead, you had a question?
well,
a comment?
my only comment was that the response, although it is electronically signed by Ms. Taryn Nix, is not attested to in any way. That
Okay. Let me take a look at the rule on that. Let's see. So our rule 16.6-6.3 talks about written complaints, sworn written complaints under penalty of perjury. So that is what counsel for Commissioner Green was talking about. I'm trying to see if I don't see a similar rule for a response. And I was looking because I didn't remember one, and I don't see one. In fact, I don't see any reference to a response. So I understand the question. I'm just not sure that it would have been called for under the rules. Ms. Miller, do you recall anything of that nature coming up before when you were chair?
No, I don't. I don't think there's any requirement that a response be sworn. It's not evidence. It's just a presentation of the respondent's version of the facts of that. So that doesn't cause me any concern.
Okay. Right, so should we just, do you have anything else on that, or?
No,
Okay. So is there any discussion about the complaint against Taryn Nix by Victoria Murphy? And with the understanding that we do have the response by Taryn Nix that we did not have before. Any issue on any of that? Turn the page. All right, I'm not hearing anything. Is there any motion?
The only thing I would add on the discussion is just, I mean, obviously, I think it's exactly similar to the previous case. The only thing I would add is, I think the intent behind identifying campaign materials is just transparency, which is good for the public, right? And so I think that trying to avoid these issues in the future is important. Just putting the treasurer's name, it's probably not that big of a deal on any flyers or if you're talking to somebody hosting a party, but I also understand that, this gets at the 100 people issue. So, to be safe and to make sure the I's are dotted and T's are crossed in the future, I would just suggest that candidates pay attention to that because that's how you end up in hearings like this. A lot of folks probably don't want to be spending time doing this and would rather be campaigning. So.
Okay, so any motion?
I would move to dismiss complaint 2025-1 for lack of legal sufficiency.
Okay, and that's also without prejudice, is that also one of those?
I left that out because I don't really know what that. The complainant has another reason to file a complaint. Do it, but I don't think there's any. I don't know that it makes a difference for us to say with or without prejudice. I think our finding today is that this complaint, or if what I would propose as a motion is that this complaint as filed is not legally sufficient upfront.
There a second?
Second.
Okay, take the roll, please.
Member Miller,
Yes.
Member Sullivan. I'm sorry, excuse me. Member Amer,
yes,
Member Black,
Yes.
Chair Biederman.
Yes.
The motion passes.
Okay. Now, the other thing on our agenda for today, and thank you for sitting in, Commissioner Green. The other issue on our agenda for today is more general discussion, which is not going to be an action discussion, about the possibility of revising the City of Santa Fe Ethics Code. And that was something that we raised as new business at the last meeting. We discussed the possibility, we didn't go into any details at all, but the general idea was to see if there were ethics rules that either did not exist for the city that should, or if we, the board should try to persuade the, or offer to the city council, maybe is a better word, offer the possibility that complaints under some rules that exist, or maybe some new ones, might be brought to us. And in particular, I was thinking, in bringing this conversation up, I was thinking that there might be ethics rules that we already have, but to get them resolved is too difficult without our intervention because it has to go through too many steps elsewhere. Or it can't be resolved within the city structure at all. And by that, I was thinking about things like sexual harassment, where there is some provision for that. But because of potential conflicts, it might not be possible to resolve it, and we don't have any jurisdiction to do that. So what I did was I looked through our ethics code as it exists, not the election code. We always think about that, and we get the vast majority of our complaints seem to involve the elections. But in other respects, I think there are ethics issues that are along the lines that I was concerned about that may not be really able to be disposed of properly, and that may put people in a conflict of interest. And I came up with a list of things that I thought were potential gaps. And this is only to, again, raise these issues. I'm not recommending yes or no on anything. The possibility of harassment being brought to our board, the issues about counselors influencing city staff. Now, let me just pause for a moment. Just so you understand where this idea came from. I teach ethics through a New Mexico State University extension program called EDGE. And one of the things we do is we ask the students to, after taking a certain number of classes, to come up with a project. And this culminating project earns them a certificate from NMSU in ethics. So, and they do that for other things as well, but I'm involved with the ethics. And so the issue that arose for me, because the issue that arose was that I looked at some of these codes that people submitted in support of their culminating projects and found that there were some things that we didn't have that they do. Counties in particular, because that's usually the people I'm dealing with. It's more counties, although occasionally municipalities. So looking at that, I saw that one thing that appears in a lot of these ethics codes I was looking at from other local government bodies involve counselors potentially interfering with the operations of city staff, interfering with the chain of command, and trying to get the benefits from staff for constituents. And there's really nothing that I saw that was very clear about that. There were one or two small sections, but nothing on the scale of what I saw from other entities. And I just thought it's worth considering whether we want to enlarge on the little bit we have. Then there was discrimination. And we know that the Human Rights Commission for the state does enforce anti-discrimination policies. And I think those are becoming greater and greater concern with the current view of discrimination that the national, the federal government's taking, which is kind of reverse of what we're used to. But I think discrimination issues might be fleshed out somewhat, and we might look to, again, this board dealing with that. And right now, it seems like at least one reading, if we're correct, of the current rules might be that the very person who would decide these things may be the city manager, if that's correct, and that the city manager would have appointed a lot of the people that would be complained against. So that puts that city manager in a difficult conflict position. You know, I chose these people, I put them in this job, I oversee them, and now they're doing this. Well, one of the problems is if discrimination occurs and a person who's supervising the people doing the discrimination or harassment or something like that, if that person is observing it, they themselves are responsible for not doing anything about it. So that's where we could be an independent source. Again, I'm not advocating this. I'm just suggesting these are the way that this is the way that other counties have been dealing with it, at least. Maybe some dealings with customers, and there were some specific sections I could point to, but I'm not trying to advocate anything. Again, I'm just trying to raise these as questions. I think we do have a pretty decent project, a pretty decent set of rules. That's it's nothing to be ashamed of. I do think that we could strengthen some of them, however. So my thought is the timing of this, and it was a while ago that we met, might not be so bad since we're going to have a new mayor and we're going to have a couple of new councilors for sure. And, you know, we don't know how many, but several. And that this council, if there were still time, we're kind of running out of time, I think, but if the council had time, they could enact something that would be applicable to the next council and mayor. So with new people coming in. So that's my thought. And I wanted to throw that out to the board and see what, whether we should go ahead with any of this, whether, you know, whether there's better ideas or anything, just a discussion. Who wants to, if anybody has comments?
Yeah, I was involved in some of this process, and I think we should continue to pursue it. Specifically, the one area that you mentioned is an interesting one because, you know, I think it would be really difficult to parse out just the general duties of a counselor versus trying to influence staff. That being said, you probably could figure out a line to draw, but right now I think it would be difficult.
And I would say that there are such rules in other entities, so we might look at theirs to see if they would work for us. Other questions or other comments?
When was this, when was it created and last updated? When was our ethics created? I mean, I see there's kind of a print that says maybe 2023, but I don't know if that's just when this was printed or when was this actually written and done, you know?
Mr. Chair, if I remember, we did some fairly significant revisions to the campaign code and election. I know that there was much work focused on the ethics code, which is what I understand. Mr. Biederman, you're talking mostly about is, I mean, we could look at all of the codes that we have authority over, or we could focus, and maybe that would be a good way to do it, is focusing on the ethics code. Left alone for a little bit longer, but I don't remember doing significant work on that.
Yeah, I've been on this board for about over 10 years now, and I don't recall any major revisions at all to the ethics code. And that is why I was raising that issue.
My other question is, does anyone know actually if the city has an EEO officer and that's active?
Really? Carolyn?
Chair Biederman, member Amer, there was a position that was budgeted for that. We did budget for it. However, we have not filled that position. The city hasn't filled that position.
So that would mean then that if somebody had a complaint about, say, they claim discrimination in hiring, they based on race, for example, that they would not have anybody within city government charged with the responsibility to make an independent determination as to whether or not it was valid at all. And they would, it would just go to the city manager along with the other duties that the city manager has. Is that, am I correct?
That is how I understand it, yes.
I'm sorry, I didn't introduce you before. Would you like to introduce yourself to the board?
Yeah, hi, my name is Ruby Cruz, and I just started with the city attorney's office. So I'm here on behalf of Marcos, but that's why I'm here today.
And, you know, I realize you just got here, but you don't know of anything to the contrary, any other missing piece that we're overlooking?
Nothing that I'm aware of.
So does kind of confirm the concern. You know, and again, I'm thinking that the city, that you know, this has not been adapted to the fact that we have a strong mayor, as I recall. So we have the strong mayor position, and that changes some things because the city manager isn't the exclusive authority over administration of the city the way that the mayor that the manager used to be, and now the mayor takes a lot of that responsibility. So politics can theoretically, I'm not saying with any, this is not reflecting on any individual who's in the position now, but theoretically a mayor could become political about that and deal with it politically, as opposed to an independent kind of body like us, or at least an employee like that. So I think those are, you know, those are some things we need to look at. Anything else, Andrew? Mr. Black, I should say.
Yeah, I mean, I was curious about Justin's comment on the campaign side of it too. I mean, obviously, you know, we have a whole section on campaign signs, but social media has become the campaign sign. And I think, you know, thinking about where the puck is going on a lot of this and how elections are being interfered with and things like that, I think is really important for this body to consider. And whether, you know, I'm not saying we need to go in and revise everything, but I think looking at it through a lens like that of the challenges we've had in the past on this committee of dealing with some of those things, and whether we've got relevant provisions around those kind of things, because I do think, you know, the idea of signs is important, but we're, you know, a whole lot more is living on social media, and a whole lot more damage can be done in that way too, to free and transparent elections. So I think it's something to consider for this body. I was just kind of looking over some of our materials and wondering if we have enough sufficient provisions around those kind of things, because that's where everything is moving.
Zamer?
Yeah, I would agree. And in addition, you know, just for instance, with what we were discussing before, disseminated by the campaign. Well, if the campaign is using AI, is it disseminated by them? Or if it's disseminated by the AI, I mean, I think there's a lot of considerations. And certainly I don't have the answers, but I agree with you completely.
Great. So now we'll be having hearings about robots, right?
Right.
Oh, okay, I can see that coming. Okay. So how should we proceed? What are people willing to do here? One thing I can see we could do is we could make a couple of lists of items that we want to address and go into subcommittees, not here, but schedule subcommittees to do some research and discussion and come back with proposals to the full board. What comes to my mind is some of the ethics. We could probably handle the ethics issues that I was talking about in one committee, and then any needed reviews of the campaign laws in the second committee. And I think that complies with the Open Meetings Act, because we're going to be doing that meeting in subcommittees that are less than a quorum and not in conjunction with today's meeting. So I think that's allowed. Does that sound good to people? Okay, is everybody willing to participate?
But just to kind of nail it down, are we trying to finish these two subcommittees' works prior to the election, or we don't have any kind of internal?
I think that ship has sailed. I don't think we can do it. So it would have been nice, but that's it. And there's no lame duck period, right? I mean, it's they take office like days after the next day, right?
January 1st.
Oh, January 1st. Okay, we got a whole month and a half there then. It's better than I thought. Yeah, we'd have a little time to try to send something to the city council. They meet every 2 weeks, right? So yeah. I know getting on their agendas,
After last night, I think we have 4 more meetings left in the year.
4 more meetings.
We only have 1 in November and 1 in December.
Oh, 1 in December.
Yeah.
Okay, well, I don't know if we put our nose to the grindstone, maybe we can come up with something in time for the December meeting if we could reserve a spot.
Yeah, Mr. Chair, we might also, I like the idea of setting up a couple subcommittees. And one focusing on ethics, one on campaign codes. I'd be willing to serve on either one of that. But it does seem like it would be a rush to get it done before. And I also don't see, I mean, it seems appropriate to, since there will be a new mayor and new councilors, to have those new officials part of the process, and councilors, councilors are going to be voting on those ordinances and those changes, rather than the ones going out the door. But so
It may be appropriate, I just from my experience in politics for 45 years, it probably would have been easier to get the current council to vote for something that doesn't apply to them, but that's okay. Just, I was being a little Machiavellian, I'm sorry. Okay, so that's not unethical. Okay, so all right, well, let's not worry about the timing, but let's schedule another meeting. That'll give us a deadline, and if we can do that, and then try to at least get something together, see what we can come up with at the next meeting as potential changes. Okay, who would like to serve on each group? And I guess we have 2 missing wait, how many? Just, yeah, 2, right? Yeah. 2 missing members today, so we'll just assign them whatever comes up short. So I'd like to be on the ethics committee. Who?
Yes, I think I've already started my
Yeah.
participation with Ms. Brennan.
And Ms. Brennan, I think we'll include her as well. Just pick that up. And you would suggested you're interested in the political
Campaign side.
campaign signage in
Yeah,
particular.
Campaign side of the.
Campaign side, okay. And Mr. Sullivan?
I think I'll join with my former law partner, Christina Brennan, and do the ethics.
Okay. And that leaves you for the campaign issues and oh, not
okay, sounded like you had 4 people on ethics,
and 3 on the
but you can't have a subcommittee for.
oh, you're right. Yep, sorry about that.
Well, I can move to the other committee
Yeah,
if
let's do that.
if needed.
Well, you've already started on this one though.
Right.
Well, you said you'd serve on, so, okay, so 1, well, how about, can you switch to something else? Can you switch to the other side?
Well, since it's my first day, I'm open for anything.
Okay, so one of the 3 of you, Mr. Sullivan, Mr. Black, and Mr. Miller, serve on the campaign committee. Thanks for catching the quorum problem. And Ms. Amer and Ms. Brennan and I will serve on the ethics committee. Okay. Okay, and what else do we have, Geraldine? We can still
next,
accept-
There's public comment.
Public comment. We have one member of the public and 1 member of the press. You're gonna pass? Okay. Let's go.
Well, thank you very much. Justin Green, 611 Fontana Place, Santa Fe, New Mexico. Don't have to swear myself in, but I do encourage you to look at campaign. So if you're going to do stuff, look at PACs, right? There have been some concerns raised in this campaign with some PACs that are quote unquote not registered here, registered federally, with you know, candidates controlling the PACs, all these things, having a clear set of rules. You know, I don't think you need to write the rules necessarily. I think there's probably good rules out there at the end of the day that you can find from other jurisdictions and stuff. So just go, you guys are the lawyers, you know how to research. So I would just recommend that. And I wish you good luck with that because it'd be great to have it for this campaign, but it's probably too late. So it'd be great for the next one. Thank you.
Thank you. And for anybody who doesn't know, Commissioner Green is a county commissioner right now. Huh? The county commissioner, right? Yeah. Well, we like to be friendly with them. Okay, so looking at the agenda, we don't have an executive session to convene. Any matters from staff?
The only thing I would say is that the clerk did want me to look for dates for a meeting in November. You mentioned to meet sometime soon. Does November work?
Does if
Or you want to meet sooner?
I'm traveling, so I won't be able to meet sooner. But November's okay. Yeah.
Okay, I'll find some dates in November and see if I can get a quorum.
Thanks. And actually on the staff, I'd like to see if we could get some support from the attorney's office for our work because there may be some research or drafting that we'll need. I know you guys are busy, but it would still help a lot to get that. And this is really interesting stuff, right? You're a newcomer, you're gonna love it. Okay, okay, any other matters from the committee?
Chair, I was just going to point out, if you all could make the changes to the form, I think that would be helpful, just to get some of those technicalities out of the way. I think that would be really great.
Can I add that, yes, that might be something we could consider approving or discussing. I don't know whether we need to approve it, but looking at it at the next meeting.
The form?
Right.
Okay.
Before-
Yes, absolutely.
Yeah, we could put that on the agenda and
Russ?
I would say, I don't think you have to wait until then to fix it, but
Right,
wouldn't wait 2 months to fix it, my point.
I agree because there might be more complaints
was
ready
just-
to be filed. You're right.
Yeah, I was just going to say, we're in the throes of the election right now, and that's when all the complaints come in. So if we wait till approving it, you know, we're just going to get the same old form until we do. So I think, you know, I think you can go ahead and do it with the help of the attorneys. Okay, no other matters from the chair. Is there a motion to adjourn?
I make a motion to adjourn.
Second.
Okay, seeing no objection, we are adjourned.